defendant comes for trial, he is imbued with innocence, and he's not to be. That innocence stays with him until a jury finds him guilty beyond a reasonable doubt. And by saying, I want to see him weasel out of this, it's implying to the jury that he has the burden to weasel out of these things or to get out of these things, where in fact it's the DA that has the burden. The DA has to prove beyond a reasonable doubt that he committed these crimes and is not permitted to shift that burden. And that's something that the Lewandowski opinion addresses, and a similar error was committed in that trial.
What about the level of her emotionalism in the courtroom? Is that an issue?
It can be an issue. You know, we don't have a videotape of this, so it's a little hard to draw out what her emotional state was.
For example, I have a video clip of her crying.
Mm-hmm.
I guess when the verdict was read.
The DA now this is? Or the victim, the alleged victim?
The decision in the conviction, the decision that he was guilty by the jury.
Mm-hmm.
And I have a shot of her crying,
mm-hmm.
Which indicates a level of emotionalism. Is that an issue?
I think it could be. It's not something specifically that we pointed out in this case. But as the third department indicated, you put all these things together and you come up with an unfair trial. If you look at one at a time, you might think it sounds like nitpicking, but when you put them all together, you have an unfair trial.
Well, a member of the Carroll family, as a matter of fact, Jack Carroll's wife told me that she sat in the courtroom, and I don't know whether it was during the summation by the prosecutor, but when it was finished, she said she felt like standing up saying, "Bravo, bravo." Mm-hmm. That was such a great performance. Mm-hmm. That maybe you wonder, maybe she should be on Broadway rather than in a courtroom.
Right.
What other issues do you bring up in the 440 motion?
Well, there's a whole series of constitutional problems that we think occurred during the trial. One of which was that when Mr. Carroll was first when he was first approached by the police, he was working at his marina, a shop that he owned, and the police came and he asked them whether he should have an attorney. And the police said, well, that's up to you. So he made a phone call to his brother-in-law and asked his brother-in-law to get him an attorney.
Your brother-in-law happens to be a cop, right?
That's right. A former Troy policeman.
Right.
And the brother-in-law called Mr. Carroll's sister and said to her, we need to get Jack a lawyer. He's got a problem here. They're accusing him of something. He needs to have a lawyer. So Mr. Carroll's sister and Mr. Carroll's fiancée, Mary Donahue, got a hold of a family attorney, Steve Bailey, and told him that they needed his help and that Mr. Carroll was being questioned and would he come down to the police station and assist Mr. Carroll, which of course, when you're accused of something by the police, you have a right to an attorney. If you ask for an attorney, you should get an attorney before you're questioned. And Mr. Bailey was asked to come down to the police station. Mary Donahue and Mr. Carroll's sister went down to the police station, and they said to the officer who had been questioning Mr. Carroll.
That was Steve Weber, right?
Steve Weber. They told him that they had contacted an attorney, and they asked him, is the attorney here? And Mr. Weber's exact response, according to both Mr. Carroll's sister and his fiancée, was, as we speak.
Which would lead them to think that he was in there talking to an attorney, or the attorney was with him.
Exactly.
And was he in fact with him?
And he was not in fact with them. In fact, there was a lengthy interview of Mr. Carroll where he had no attorney present. Now, Mr. Carroll, even according to the police, denied repeatedly that he had been involved in this crime at all. During that interview, he denied that. And so perhaps you could overlook the fact that he didn't have an attorney for this interview. But then when the trial came, the police used all these supposed nonverbal clues.
That's right. The way he held himself, the way he leaned over, the way he
Crossed
folded his
and
arms,
uncrossed.
crossed his legs.
Exactly.
When did they become experts in reading body language?
Well, according to them, they've been training for that their whole lives. But the upshot of it was that Mr. Carroll had a lengthy, uncounseled interview. It was uncounseled because the police had basically committed a fraud on Mary Donahue and Mr. Carroll's sister by telling them that an attorney was there.
Do they claim they told her that the attorney, did they claim something different? Do they say they told them that there was no lawyer there?
We don't have a response yet with regard to this 440 motion from the DA's office, and I don't know what their claim is going to be on that. I don't know that they've had an opportunity to address that one.
What about
his,
did they read him his Miranda rights?
I believe they did, yes.
Well, I have a copy of the statement that supposedly, or that he did give, that the police wrote up. And something about the Miranda rights seemed to be added afterwards, seemed to be written in.
Mm-hmm.
I'm sure you've looked that over, and I don't know if that's an issue.
It has not been made an issue with regard to this
But
motion.
basically, his constitutional rights were violated by that interview.
That's our position, certainly, yes.
Okay, what are some other issues?
Well, there's a whole series of technical issues regarding double jeopardy and the fact that the charges, the initial rape charges were dismissed, and whether then the DA could be in a position to re-raise the whole issue of penetration again. In other words, in the first trial, the Court of Appeals determined that there had been no penetration. They basically said that outright, that there had been no penetration, there was no evidence of that. When the second trial came around, that whole issue was re-raised. A nurse was allowed to testify about her findings, and the DA continued to try to insinuate that there had been some kind of penetration. And our position is that re-raising of that issue violated Mr. Carroll's right to be free from double jeopardy. In other words, that he was tried on that issue 2 times, even though he essentially won the first time. They were allowed to bring it back the second time, and that was error.
Now, the 440 motion that you've written up, and it's a lengthy document. It's like 28, 30 pages long.
Yes.
Where does this go? You've written it up, and I understand the district attorney, Patricia DeAngelis, the prosecutor in both Carroll trials, now has a certain number of days to answer it, right?
That's correct.
How many days?
Typically they have, I believe, 30 days to respond. The judge gave them an extension until December 6th to respond to this. And then once the DA responds, then we have an opportunity to reply to that response one more time.
And how much time do you have to do that?
Typically 10 days.
And then it goes to Judge McGrath, right?
That's correct.
And then what happens to it then?
Well, then he'll issue a decision, and he can either deny the motion entirely, he can grant the motion, or he could grant a hearing as to certain aspects of the motion to try to determine exactly what happened and to have argument about it, and then make a decision after that.
I know what you hope, but what do you expect will happen as far as Judge McGrath is concerned?
Well, I'm hopeful that he's going to review what happened at the trial in light of the Lewandowski opinion. I'm hopeful that he's going to see that the same thing that the Third Department said resulted in an unfair trial for Lewandowski also resulted in an unfair trial for Mr. Carroll.
Wasn't there already an appeal to the appellate division?
Yes, there has been.
And it was turned down?
That's correct.
Do you have any idea why they would turn that down when the same issues were involved in both Carroll and Lewandowski?
I don't think these issues of prosecutorial misconduct were brought before the Third Department in that appeal specifically. In fact, I don't think they were really raised on that appeal. So that's probably why they were not addressed by that court.
Okay, so Judge McGrath then has the option of sending it on up to the appellate division, right?
No, Judge McGrath will make a decision one way or the other, and then we will have the option of going to the appellate division and asking them to review Judge McGrath's decision on the 440 motion. So in other words, if we get permission from the third department, we'll have the opportunity to appeal Judge McGrath's decision if it's unfavorable to us.
Okay, and then if the appellate division turns that down, then do you have the option of going to the Court of Appeals?
I actually think you do not have that option. With a 440, the appeal of a 440 goes to the third department. They have the ability to either grant or deny. It's really discretionary on their part. And then if they deny your appeal to the third department, my recollection is that you don't have the opportunity to go to the Court of Appeals.
Is that the end of the line then?
There may be federal habeas proceedings that could go on. I know Mr. Carroll is working on that with regard to these issues and others. So it is possible that a federal court will then look
Now,
at it.
I understand Jack Carroll helped in putting together the 440, right?
Yes, he did.
He's become kind of a jailhouse lawyer.
Yes, to a certain extent. Yep.
So maybe that's a positive thing that will come out of this. And so you expect that or you hope, let's say that Judge McGrath throws out the conviction. Mm-hmm. Jack Carroll's free then?
He would have to potentially face another trial.
And what would happen in that case? I mean, wouldn't that be unusual to go back to a third trial?
I think it would be. It would be unusual. Not unheard of, but unusual.
So the likelihood would be that they, now especially when they offered him, after the first trial, they said to Jack Carroll, plead to a misdemeanor. He had been in jail at that point 3 years. They said, plead to a misdemeanor and you go home.
That's right.
Right.
Yep. And of course, Mr. Carroll has maintained his innocence from the very beginning here through whatever interviews he had with the police and through 2 trials and now this further proceeding that we're bringing.
The fact that they offered the opportunity to cop a plea in this, doesn't that mean that she didn't think she had a strong case? Or wouldn't it lead you to that conclusion?
That's one conclusion you could draw from that. I don't know that I would presume to look behind their thinking on that, but certainly one could assume that if they offer a misdemeanor plea, they're concerned about the strength of the case that they have.
We've got about a minute left. What's the bottom line for you in all this? Do you see Jack Carroll being freed? I know you hope that, but
yeah. Well, 440 motions are not often granted, and permission to appeal from a 440 is not often granted. So we've got a very uphill battle here. But I remain hopeful because it just seems to me that it would be too unfair to have a trial that the third department has essentially already said was unfair and to let that stand. Jack Carroll didn't get a fair trial, and he deserves a fair trial. We all do. And I'm hopeful that either Judge McGrath or the third department will acknowledge that and give Mr. Carroll another trial.
Jim Gross, thank you for being with us. Good luck.
Thank you.
It's been a pleasure to talk to you.
Likewise, thank you.
For more information about this very controversial case and to get a copy of the Justice Now newsletter, call Jack's brother Pat at 448-6950.